All right, so buckle up, because today we're diving headfirst into the world of joinder and class action lawsuits.
And trust me, this stuff is way more relevant than you might think at first glance.
Exactly. It's one of those things that might seem like legal jargon,
Hmm.
but once you peel back the layers, it affects so many aspects of how lawsuits, big and small, actually play out.
And it has a huge impact on who gets to sue, how they sue, and even whether those David versus Goliath cases ever get off the ground.
Okay, so let's start unpacking this, shall we? First up, joinder.
Oh.
Imagine for a second you have to get a message to a whole bunch of people.
Okay, I'm picturing it.
Instead of having a separate conversation with each person, it would be way more efficient to just gather them all together, right?
Absolutely streamline the communication.
Well, that's kind of what joinder is in the legal world. It's about bringing related legal claims or even multiple parties together under a single lawsuit.
Exactly. It's all about efficiency and making sure the courts aren't bogged down with a million separate cases that are essentially about the same thing. And there are a couple of key ways this happens: joinder of claims and joinder of parties.
So joinder of claims, it's like, let's say, oh, I don't know, your neighbor's dog digs up your prize-winning roses.
Ah, tragedy.
Right. And then, to add insult to injury, that same dog decides to crash your pool party later that week and, cause a whole scene. Two wrongs, one lawsuit. Is that the basic idea?
You got it. Instead of filing two separate lawsuits, you might be able to combine those claims into a single case because they involve the same parties and are stemming from a similar set of events. Let's say, for another example, you're having a contract dispute with someone, and that same person also happens to owe you money for something totally unrelated.
Like they borrowed your lawnmower and never returned it.
Exactly. Two different issues, but you might be able to address them both in a single lawsuit.
Okay, that makes sense to me. But then it gets more complicated, right? When we're talking about joinder of parties, like how does a court decide who LSE can get roped into a lawsuit, so to speak? That's where those legal rules you sent over come into play, right?
Absolutely. And one of the key ones we're looking at is Rule 20, which deals with permissive joinder of parties. Now, it's important to note this isn't mandatory, but it gives some flexibility for multiple parties to join a lawsuit or even be brought into a lawsuit when their claims involve some really key overlaps.
Overlaps like what?
Well, for parties to be joined under Rule 20, their claims usually need to revolve around common questions of law or fact, and this is a big one, stem from the same set of events.
So kind of like a chain reaction where one event leads to multiple people being affected.
Precisely. And to give you a real-world example, let's look at the Pure Kelly v. CNA case from your files. This one involved a group of employees who decided to sue their employer for age discrimination.
Okay, I vaguely remember that one. It was a big deal, right? With a lot of employees involved.
Right. Now, even though each employee had their own individual story and their own individual experiences, the court allowed them to join their claims because they all pointed to the same type of alleged discrimination, and importantly, it all stemmed from a company-wide policy.
That's really interesting. It's almost like there's strength in numbers, but in a legal sense. Oh, hold on. Then there's Rule 19, which talks about necessary parties. Now, that one always makes my head spit a bit. How does a court determine who is absolutely essential to a lawsuit to make sure things are fair and above board?
Okay, so Rule 19, that's where things get really interesting. This rule deals with what's called mandatory joinder. It's not about optional grouping. It's about the court stepping in to make sure everyone who absolutely needs to be involved for a truly fair outcome is present and accounted for.
So it's about protecting everyone's rights, even if they're not the ones who filed the initial lawsuit.
Precisely. It's about preventing those situations where leaving a key person or entity out of the lawsuit would result in an incomplete or even totally unfair outcome for everyone involved.
I see. So it's kind of like the court looking at the big picture and saying, hold on, we're missing a crucial piece of the puzzle here.
Exactly. And a good example of this is the Temple v. Synthesis case from your research. In this case, a patient sued a medical device manufacturer, but here's the catch: they didn't include the surgeon who actually implanted the device.
Oh, wow. Okay, so even though the surgeon was directly involved in the situation, the lawsuit was allowed to proceed without them.
Well, in this particular case, yes. The court determined that while the surgeon was definitely involved in the situation, they weren't deemed a necessary party under Rule 19.
So how do they make that call? What's the deciding factor?
In this case, it boiled down to whether the lawsuit could still effectively address the heart of the matter without the surgeon's direct involvement. And in this instance, the court determined that it could. The lawsuit could still proceed and still examine the core issues at play, even without the surgeon being a named party.
So it's really a judgment call then. The
Yeah.
court has to weigh all these factors and figure out the best path forward.
Exactly. And that's what's so fascinating about this area of law. It's not always black and white. The courts constantly have to balance efficiency with fairness, and that's not always an easy thing to do. They want to streamline these cases and avoid unnecessary complications. But at the same time, they have to make sure that everyone's rights are protected and that justice is served.
All right, so we've tackled joinder, where lawsuits can become a bit of a group project, legally speaking. But now let's shift gears to something that might feel a little more familiar, maybe even ripped from the headlines: class action lawsuits.
Ah, yes, so situations where it seems like half the country is suing at once.
Exactly. It can be pretty overwhelming to wrap your head around. So today we're going to break down how these mega cases actually work.
Sounds good to me.
So you see a news report about, I don't know, a faulty toaster, right? And then suddenly, bam, there are thousands of people banding together in this massive legal showdown. So how does that happen? What's the secret sauce that transforms a regular lawsuit into this legal battle royale?
Well, it's less about a secret sauce and more about meeting a very specific set of legal criteria. To morph into a class action, a case has to check off 4 major boxes. Think of them as the 4 horsemen of the class action apocalypse, if you will.
Okay, I'm intrigued. Lay it on me. What are these 4 horsemen, and what do they represent in the legal world?
So first up, you have numerosity. And this one's pretty intuitive. It basically means there are way too many people impacted by the issue for individual lawsuits to be practical. Imagine, for example, a concert, right, where something goes wrong, a stage collapses, a fire breaks out, who knows? And hundreds, maybe even thousands of people are injured.
Oh, wow, yeah.
Yeah.
I can see how that would be a logistical nightmare. It would completely overwhelm the courts if everyone filed their own separate lawsuit.
Exactly. So numerosity is about efficiency and making sure the legal system can actually handle these really large-scale situations.
Makes sense. What's next?
Okay, so the second horseman is commonality. This one means that the members of this potential class, they all need to have suffered a similar legal injury that stems from the same root cause. It's not enough for everyone to have just been wronged by the same company, for instance. Their grievances have to be rooted in the same harmful act or practice.
So it's about finding that common thread, right?
Yeah.
That thing that links all those claims together.
Exactly. And it ensures that the class action is focused and efficient. It's not a free-for-all. Now, the third horseman on our list is typicality. And this one focuses on the claims of the people leading the charge, so to speak, the class representatives.
So these are the folks who are kind of the face of the lawsuit, right? They're the ones who are really out there front and center.
Right. And their claims, the legal arguments they're making, they need to be similar enough, representative enough of the claims of everyone else in the group.
So it's about picking the right spokesperson in a way, making sure they can actually speak to the experiences of the whole group.
Precisely. And that brings us to our final horseman, adequacy. This one is all about those class representatives and their ability to fairly and competently represent the interests of the entire class.
So it's like a legal quality check to make sure everyone has a fair shot, even if they're not the ones, giving interviews on CNN.
Exactly. Now, you also mentioned this intriguing one-stroke concept that popped up in the materials you were looking at. What did you make of that?
Well, it really jumped out at me because it so perfectly captures the essence of why these class actions exist in the first place.
Right. I think you're onto something there.
I mean, the goal is to resolve this common legal issue for a whole bunch of people, but with a single judgment in one fell swoop. It streamlines everything, conserves resources, and it just makes sense on a practical level.
Absolutely. It's a way to level the playing field, especially for individuals or maybe small businesses that might not have the resources to go up against a massive corporation solo. Without class actions, many of them might find it impossible to get their claims heard, let alone to secure a fair outcome.
It makes you think about access to justice. For some folks, being part of a class action might be the only way they can even get their foot in the door, legally speaking. This next part is really where it hits home that those class action lawsuits, while they can be game changers, also come with a whole other layer of complexity.
Absolutely. It's not as simple as just rounding up a bunch of people with similar complaints and hitting the sue button.
Right. So we've talked about how these class actions can help level the playing field. But what happens when it comes to settlements? If a class action wins, or maybe they reach a settlement, does that mean everyone who might have a claim automatically gets a check in the mail?
That's a great question, and it takes us right to the heart of one of the most crucial aspects of class actions, the settlement process. See, unlike in those typical one-on-one lawsuits, settling a class action isn't just a matter of the parties shaking hands and calling it a day. The court plays a very active role.
So it's not a done deal as soon as the lawyers high-five each other. Interesting.
Nope, not at all. There's a whole rule dedicated to this, Rule 23E. And it requires the court to actually give the thumbs up, legally speaking, of course, to any settlement agreement.
So why is that? Why is it so important for a judge to sign off on these settlements? What are they looking out for?
Well, the court is essentially acting as a guardian for the entire class's interests, especially because you might have individual members who don't have the resources or maybe even the awareness to fully advocate for themselves.
That makes a lot of sense. It's like having that neutral third party come in and make sure everything is on the up and up.
Yeah.
So what kinds of things are those judges looking at when they're deciding whether to approve a settlement? What factors come into play?
They're considering a whole range of factors, but some of the big ones include how strong the plaintiff's case is, so, how likely they are to win if they go to trial. They also look at the potential risks and costs of dragging the lawsuit out even longer.
Because those things can really add up, both in terms of time and money.
Exactly. But one of the most significant factors is the actual relief being offered to the class members. Is it fair? Is it reasonable? Does it genuinely address the harm that was suffered?
So the court is really trying to make sure the little guy is getting a fair shake.
Absolutely. That's a big part of it. They're looking out for the entire class, not just the lawyers or the named plaintiffs.
Now, let's say I'm part of a class action, and I'm not thrilled about the terms of the settlement. Maybe I think the payout is too small, or I don't like some of the strings attached to it. Do I have any say in the matter? Or am I just stuck with whatever the lawyers have cooked up?
No, you definitely have a voice. It's not a dictatorship. Class members, they actually have a legal right to be informed about the settlement terms. And not only that, they usually have a chance to actually object to the settlement if they believe it's not fair or doesn't really address their losses.
That's good to know. So there's some built-in accountability. It's not just a done deal.
Exactly. And this is where that Hansberry v. Lee case we touched on earlier becomes so relevant.
Right. That case really highlights just how crucial those individual rights are, even when we're talking about these big, sweeping class action scenarios. For our listeners who might not remember all the ins and outs, could you give us a quick refresher on what that case was all about and why it matters so much?
Absolutely. So at its core, the Hansberry case was about this racially restrictive covenant that was placed on a property, essentially, trying to use legal means to prevent people of certain races from living in a neighborhood.
Yeah, and there had been this previous lawsuit about it, right, where a group of homeowners had basically given a green light to this discriminatory practice.
Right. They argued that enough homeowners were on board with this covenant to make it enforceable.
But the thing is, the homeowner in the Hansberry case, they weren't even a part of that initial lawsuit. So they were basically trying to benefit from a ruling that was made in a case they weren't even involved in.
Exactly. It just highlights how important it is to make sure everyone's rights are protected, even when we're dealing with these large-scale cases.
Well, I'd say we've covered a ton of ground today, from those more straightforward lawsuits involving joinder, all the way to the wild world of class action lawsuits. It's been quite a journey.
It has, but honestly, I think these are some of the most important concepts for people to understand because they underpin so much of what we see playing out in the legal world every single day.
They really do. So for our listeners who might be thinking, wow, that was a lot to take in, what would you say are the key takeaways? What do you hope people will remember from this deep dive?
Well, first and foremost, I hope they'll come away with a better understanding of how these legal mechanisms work and how they can be used for better or for worse to shape outcomes. And I especially hope people will remember that even in these complex legal battles, especially in those massive class action situations, individual rights still matter. Every voice deserves to be heard.
Absolutely. Well said. And on that note, we're going to wrap up this deep dive. But don't worry, we'll be back soon with another fascinating topic to explore. Until then, keep those legal minds sharp.